Good morning, everyone. A very warm welcome to you all on behalf of Education Nest. My name is Khushi Mishra, and I am the host for today's webinar on the topic New Labor Codes. In today's rapidly changing work environment, understanding labor laws has become more important than ever, and the new labor codes represent a landmark reform in India's labor legislation by consolidating multiple existing laws into simplified codes aimed at strengthening workers' rights, improving social security, ensuring compliance, and promoting ease of doing business. This session has been designed to provide clarity, awareness, and practical understanding of these reforms for students, professionals, and stakeholders alike. To guide us through this important subject, we are honored to have Advocate Prerna with us. Hi, ma'am. Thank you for associating with Education Nest. Ma'am, actually, you are on mute.
Yes, hi. Can you hear me?
Yes, ma'am.
Yes, please.
Now, before moving forward, I would like to give you a brief introduction about ma'am. Advocate Prerna. Advocate Prerna is an independent legal practitioner based in Delhi with over 20 years of post qualification experience. Her practice spans across labor laws, corporate compliance, litigation, advisory, mediation, and arbitration. She regularly appears before the High Courts and District Courts of Delhi and NCR, as well as various tribunals including DRT, DRAT, Consumer Forums, and RERA. She is also empaneled with several public sector undertakings and NBFCs. Advocate Preda holds qualifications including LLM, LLB, Diploma in Labor Laws, Diploma in Cyber Law, and a certified mediator. She is also a POSH and legal compliance trainer and serves as an external member of internal compliance committees for reputed organizations. With her extensive hands-on experience in advisory corporates, PSUs, startups, and HR teams, she brings strong practical insights into labor law compliance, making her the perfect expert to guide us through today's topic on the labor codes. Okay, ma'am. Okay, everyone. Now, ma'am will continue the session. Ma'am, hand over to you.
Thank you, Ayushi. As you've already given in your introduction, that I think it's echoing.
No, ma'am, it's not echoing.
No, okay, fine. So, as you've given in your introduction, there have been labor laws amendments. Now we have not just amended the labor laws, we have repealed a few labor laws, and we've come to four basic codes. Now, what had happened in 2002? I'll give a brief history. In 2002, the Law Commission suggested for amalgamation and categorization of the various labor laws, and so that the registration, compliance, and all these factors, the compliance was an issue. So all these factors, they were creating a lot of hurdles in implementation of the provisions and creating a kind of a deadlock at times. Now, to solve that issue, to resolve that issue, the commission suggested that since there are overlapping of a few provisions, and those provisions in one code had a different interpretation, the other code had a different interpretation. So all these created hurdles in compliance. So to get rid of that, the four codes have been suggested so that the entire labor law can be amalgamated and categorized in such a way that particular set of laws that are applicable, for example, wage. Now, for wages, we had three different laws. Okay, so similarly for Social Security, now Industrial Disputes Act had some facilities, some provisions. The other acts had some provisions. Then application of various laws also were different in some establishments. So what was happening was that everybody was kind of, in a fix what exactly should be done. So that led to disputes, that led to a lot of industrial disputes. Courts were being flooded with the cases, and the loopholes were also being utilized or misutilized by both the sides, the employers and the employees. So to curtail all that, these four codes have been introduced. So we have the four main codes were the code of wages, that is that deals with the payment of wages and the minimum wages. This was in 2019, enacted in 2019, and some provisions came into operation in 2020 itself. But the other provisions, the most of the provisions were still yet to be notified. So this year in 2025, the entire act has been notified. So entire act has come into effect. Then we also have rules framed under the Code of Wages Act. Now, Code of Wages Act was the first. It was in 2019. Now we have certain rules also framed. This is the first act that has got the rules. Rules were also brought into effect in 2025 itself in September. So to ease out any provision, to understand and to implement a provision, rules are important. So until unless the entire rules are brought into effect, the act cannot be implemented as such. And what will happen is that if there is no rule, then the earlier rules that were applicable, that will continue to be in operation, like we have for the other codes. The other code is Industrial Relations Code. This is of 2020. The remaining three codes were enacted in 2020. And now they have all brought into the entire set of four codes have been brought into effect this year. Then the third one is Code on Social Security. Then the fourth is the Occupational Safety, Hazard, and Working Conditions Code. This is also of 2020. Now, Social Security Code also had certain provisions that had come into effect in 2021 itself, but now the entire act is in force. Now, these three acts, they do not have any rules as such framed. Rules are still being drafted. So until and unless these rules are drafted under these codes, what is going to happen is that the respective rules that were framed under the acts that have been amalgamated into these four rules, these four codes, will still continue to be in operation until unless we come with the rules and repeal the earlier rules. So there is a little conflict also still. It will exist because there again a number of acts were there. Every act had its own rule. So that conflict will still continue to exist under the other three codes. So I'll be sharing my just a minute.
Yes, ma'am.
Yeah, can you see this?
Yes, ma'am. It's visible.
So first we get to the first slide. That this has the details of all the acts that have been amalgamated in these four codes. So the code one is code on wages. Now this is not code one, code two, code three in that sequence. This is just I have mentioned code one, code two. Otherwise, it's nothing like that. So the code is Code of Wages Act, Code of Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. So these four acts have been incorporated, amalgamated into the Code of Wages Act. Then we have the Industrial Relations Code. In this, Trade Unions Act, the Industrial Employment Standing Orders Act, and the Industrial Disputes Act. Three acts have been amalgamated. The third is Code on Social Security, where you have the eight that are listed, eight acts that have been amalgamated. The maximum number of the acts have been amalgamated in the fourth one, that is the Occupational Safety, Health and Working Conditions. These had 13 acts. So you see there are 29 acts. These are central acts. Then you according to these, there you also have the state acts. Now, these codes do not repeal the state acts. They do the state acts, the respective state, whichever state has come up with its own statute under the aegis of the central rules, the central acts, they still continue to remain in operation. So until unless there is a further notification that all those state acts and state rules are also repealed, there will be a conflict. And that conflict will be to the extent that the state acts are not in conflict with, or they do not make the state acts redundant. So if there is any discrepancy, then the state acts, state codes, the central codes will prevail. But still, like for example, minor things like registration or minor procedural compliance, these will then keep bothering because they have not repealed the state acts and the state rules. All right. So then we go to the next slide. Now, the major highlights why we came to why the necessity was felt to enact these four codes that I've already given in the introduction. But the major highlights come in the form of these. What is the basic benefit is, number one, that the employer definition has now been included. It now includes manager, managing director, contractors, legal representatives of the deceased employer. Now, earlier, these things were all on the basis of interpretation of or the judicial intervention. But now, the word employer includes anybody who is working on behalf of the employer, who is directly employed by the employer, like, for example, the contractors. And by whatever name, for example, the manager or managing director, all will be considered to be an employer. Then it introduces one license, one registration, and one return framework. Now, the earlier act had number of compliances in terms of registration and licensing. So registration is now single, one registration form. But of course, there will be, again, as I said, there will be compliance according to the state registration procedures and the state registration laws. But these four codes, on the central level, these four codes provide only for one license and one registration. Then they have the uniform threshold of 10 employees has been set for electronic registration. Now, you also have the provision of electronic registration. So for that, at least 10 employees less than 10 employees, that is voluntary for the employer. But if there are 10 employees, then there is a mandatory provision that it has to be for electronic registration. If you want to go ahead with the electronic registration, there has to be a 10 employees, or you can interpret it otherwise also, that if there are 10 employees, then you have to go for electronic registration. Then there are now see what used to happen there. People used to have, the employers, they used to have manual registers, manual records, which could be manipulated at any point of time. So as a lawyer, I really appreciate this part of the amendment, because now these electronic records will have to be maintained by the employer, and these will be it's very difficult to otherwise manipulate electronic registers, electronic records. So these will come handy whenever there is any dispute. So there are now provisions for electronic maintenance of records, the registers, and the returns, because you have to file the returns, you have to maintain what compensations are given, you have to maintain how much compounding has happened, has taken place. Now, all these things, any benefit that has been given, any payment that has been given, all these will be, any set off has been made, all these will be maintained in electronic form. So they will be good compliance in the form of electronic records, and these will form evidences in the courts, which will be very difficult to manipulate. So things will be, adjudication of disputes will also be easier and better in this case. Then we have decriminalization. Now, earlier, what used to happen there, the other acts, I mean, the 29 acts, they did not have this kind of a provision where the penalties can be compensated. I mean, can be exchanged for compensation, or the offenses can be made compoundable. So these decriminalization of minor offenses, first time offenses, and compoundability is a very major step in uh, enacting these four codes. So if there is imprisonment only only for one year, then okay, this has to be borne in mind that compoundability is also of offenses which have only 1 year imprisonment, not more than that. So compoundability is only when a person has committed an offense for the first time, if it is just payable by fine, or if it entails imprisonment for less than 1 year. So then we have opportunity to rectify non-compliance. So if there is any non-compliance, there is provision for rectification also. Straight away, no need to, because these things also increase on the burden of the authorities. So straight away, no need to go for any kind of legal action. Here, you can also initiate action after giving notice for rectification. So this is also a major step. And for this, there are inspector come facilitators appointed. Earlier, there was no facilitator. Earlier, there was only an inspector. And inspector was also kind of a very strict authority. They did not have any compoundability or any relaxation or compensatory powers. They could do was that they could take legal action, they could impose fine. So now this is also a very appreciable step. But one thing is to be borne in mind, that if there is a repetition of any offense, then there is no opportunity for uh, rectification, or there is no opportunity for even compensation or compoundability, nothing. Then legal action has to be taken care of. So now we come to the next stage, the next slide. So next, now we have the code of wages. These are the highlights. What exactly have been thought of to bring about the code on wages? One is no wage threshold. Earlier, if we see the early act of the Payment of Wages Act, now there were different thresholds of applicability of the various acts in the earlier regime. This time in the code of wages, there has been no provision has been provided to limit the applicability of the acts. So now all kinds of employment, all kinds of employees will be governed by code on wages. No threshold. Next is no threshold on statutory bonus. Then now this is yet to be notified by the government what will be the threshold. But then yes, there was a limit to for the application of statutory bonus in the earlier regime. Now, and this statutory bonus part is also very significant, because earlier the disqualification part was very restricted, very limited, and the rest was dependent on the court interpretation. Now, after the commencement of POSH Act and after the implementation of the provisions of POSH Act and strict implementation of the POSH Act, now sexual harassment, now because this act has come after 2019, this code has come after 2019, so sexual harassment becomes a ground for disqualification of bonus. Now we have floor wages. This was never there in the labor law environment. Why? Because there was no fixed fixed minimum, fixed wage beyond which the minimum wage had to be ascertained. So every state had its own minimum wages. Every sector had its own minimum wages. Now here the government has come with a floor wage. With the floor wage, it is kind of a standardized wage. Any enactment, any new implementation on minimum wages will be above this floor wage. So minimum wages is one aspect where you cannot pay any employee beyond, less than that minimum, but that minimum also has to be above this floor wage. So there has to be a strict compliance of this. Otherwise, this again can be very dicey for the employees, and employers can also be pulled up on this, because lot many people would try to put the minimum wages at par with the floor wages. So minimum wages is also there, floor wages is also there, and these have to be in alignment. So this provision is a very, very major step, very appreciable step in the code on wages. Now we have timely payment of wages and deductions. Earlier there was no timely payment. Anytime any employer, because there was all manual registers, manual application, and manual execution of the provisions. So the employers used to pay any date. Somebody was getting before 7th, somebody was getting by 12th o'clock, by 12th of the month, somebody was getting up to 2-3 months. Now with this code on wages, the employers are now bound to pay wages within the stipulated time, which is kept at 7th of the month, if it is on a permanent, on a monthly salary. And for the daily wages, again there are graded dates for daily wages, then for weekly, then for time bound. So that we will see if we do a session on the wages act, or on the acts, on the codes separately. Now here, since I am restricting myself to uh, only an introductory part, so I will not go into details, but then this aspect is a very welcome step. Then we have decriminalization of offenses, as I said, because decriminalization was a very awaited and a very welcome step in this. This part is of significance, where employer can get rid of also. So it has to be considered in a very considered manner, in a very thoughtful manner, how to go about the monetary fines of the compensation. Earlier, okay, it was imprisonment, so everybody was scared of imprisonment, or for whatever penalty was imposed. But now, so after decriminalization, it becomes very important for the employer to get into, for the authorities to get into the aspect of monetary compensation, because here it is only by paying 50% of the fine. Now these fines anybody can get rid of by paying 50%, and then they can just be okay with it. So the authorities also need to be very vigilant on the implementation of code on wages provisions. Then gratuity, graded penalty. For different types of gratuity comes in the other code, it's not here. Graded penalty, now we have penalties for different stages of contraventions. If it is for one time, then if it is for a repeated within 5 years, then there is no compensation, there is no compoundability, as I said. The payment of wages is a major issue, and it has been already brought into effect in 2020, and the rules in 2021. So this has been taken care of in a very thoughtful manner. Then now we have the Industrial Relations Code. Now, Industrial Disputes Act was a major, as a lawyer, I'm saying it was a major contributor to labor law pendency and labor court pendency, because every small dispute arising out of industrial relations came to the industrial court. And in the industrial tribunals also, now the writ courts. Now, let me tell you one thing, there is a bar of jurisdiction for the provisions for the implementation of these codes. But that doesn't mean the writ jurisdiction of High Court has been taken away. The writ jurisdiction was also there. So what used to happen in the earlier regime, any small deviation on natural justice, or on principles of natural justice, or on speaking orders, or on perversity, that used to go to the writ court or the High Court. So to reduce that, there also have been considered effort to bring all those disputes within a framework where where the resolution is easier, where the resolution is beneficial to both. So we have the industrial relations code. Now here there is a term called, and the major part was retrenchment in the disputes. So here you see, I will discuss with that. The retrenchment part, the reskilling part, all these have been taken care of so that the employees do not suffer and the employers are not put in a quandary. So the employer to have a flexibility of fixed term workers. Now what used to happen, there was no permissibility of a fixed term employment. So either they retrenched without any what you say, any reason, any rhyme or reason, just for cost cutting, or they recruited in a way that was not beneficial to the workers. So the employer was also dragged into litigation all the time. Now here the employer will have, considering his limitations, considering his working requirements, he will have a flexibility to employ fixed term workers. And with this, there is no restriction in this. Any sector, any employer can have flexibility of employees. They can be employed on fixed term basis. Now, the definition of industry has also been modified, and the aspect of distribution, there are distribution centers. So, the distribution centers were not covered under the industry. It was basically related to sales and manufacturing. Now, the distribution part also has been taken into consideration in the Industrial Relations Code. The worker reskilling fund, this is very important because, as I said, the retrenchment happens without any rhyme or reason at times. So the employers were also dragged into litigation and they had to frame a policy which were kind of not very beneficial to the employee. But again, that part also dragged the employees into litigation. The contracts that were framed, that also dragged them into litigation. So now here, reskilling fund has to be provided, has to be maintained, and this will provide monetary support for reskilling of retrenched or laid off employees. So uh, with the introduction of reskilling fund, now at least the employers will have some peace of mind, because then if they retrench or lay off, then they can reskill their own employees. They do not even have to hire the employee from the open market. They can reskill skill their own employees and re-employ them. Because sometimes a unit doesn't function, a unit has to be closed, and sometimes retrenchment has to take place because of certain unavoidable conditions. Then in that case, the same employees can be reskilled by the employers. Then we have trade union recognition. Now, trade union was one big bottleneck for industrial growth. So to curtail that, and there were a number of trade unions, even every small trade unions, they had the bargaining power. They used to have they used to connive with each other. They would group in together and then they would bargain for their rights against the employer. So for ease of business, to have some breathing space for the growth of the industry and the industrial establishments, and for some relaxation to the employers also, what is now happening is in this code, the Industrial Relations Code, now even if you have number of trade unions, only the trade union which will have the maximum representation, that is of 51% of membership, will have recognition. Otherwise, the provision is of only one single trade union, no multiple trade unions. And trade unions are also backed by political parties. So every trade union would approach a political party, form a trade union, and then create bottlenecks, create impediments. Now here, this provision is for only one single trade union. And if there are number of trade unions, then it will be only the one union that has more than 51% of membership. If the number of membership in other unions are less, in all the unions are less than 20%, then there will be a negotiating council, meaning they will come together, form a negotiating council, and the negotiation will take place between the employer and the negotiating council. No single trade union with just a small number of membership can come forward for a discussion on the negotiation. So this trade union recognition, and one more thing is important in trade union recognition that has been provided in this code, is that the trade union will have to be registered under this code only. No society, no Companies Act, no other law will be applicable on these trade unions. So whatever union has been formed, it has to be registered under the Industrial Relations Code. Then the threshold. Now, earlier, what used to happen for layoff or retrenchment, the number of employees, the approval limit was limited to 100 workers. Now it has been increased to 300 workers. This is a major step when we consider MSMEs, small scale industries, because they do not have, not necessarily they will have 100 or 150 workers. They can even work for 200, 300, and they can even work for 120, 115. So with such a small, considering the level of work and the level of compensation, the number of benefits, social security measures that have to be taken, the number of facilities that have to be provided. So all these things, if you take into consideration, then 100, 150 workers, sorry, excuse me, was the threshold for in case there is any layoff or any retrenchment is contemplated. Now that has been enhanced to 300 workers. So this will benefit the medium, small scale, and the smaller units more than the larger units. Larger units always had the benefit of having more than 100 workers. So that part is there. But for MSMEs, considering the MSMEs, because now MSMEs are also growing. So after that, after the enactment of MSME Act, this part became very significant. So 100 to 300 workers threshold has been enhanced to standing orders. So for working conditions, standing orders are required. And standing orders, registration of the standing orders was also mandatory. It is now again, it is still mandatory, but the threshold limit has been again increased to 300 workers. Then we have the grievance redressal committees. Now this is very important. As I said, for industrial disputes, form the largest chunk of dispute resolution and pendency of cases in the courts. Now here we have a grievance dispute redressal committee which will resolve the dispute. So now we have a 3-tier redressal. First will be grievance redressal committee. This is a mandatory committee where there are more than 20 employees. This will also have women representation. So if there is any gender sensitized redressal required, women representation will ensure that. So after this grievance redressal committee, then we will have the industrial disputes tribunal. From there, we have the in the National Industrial Disputes Tribunal. So there are 3 tiers. If you are aggrieved by the redressal committee, you can approach the Industrial Disputes Tribunal. Then if you are aggrieved by the Industrial Disputes Tribunal, and either party can approach, then we have the National Industrial Disputes Tribunal. So the redressal will become easier, will become more feasible, because here in the grievance redressal committee, both will have representation. Women will have representation mandatorily, because it may not be necessary in the tribunal, in the court. Also, if we approach the court, there is not necessary that the presiding officer will be a woman. But in the grievance redressal committee, women representation have to be there. Then we have the notice for strikes and lockouts. Now, earlier, the notice period was limited. Of 14 days notice period was limited. So anytime, any day, people would call off a strike and go for mass casual leave. Now, mass casual leave has been included in the strikes and the definition of strikes and lockouts. So even if you get, go for a mass casual leave, now this is a very good reprieve for the employers. Because why? Because mass casual leave was nowhere covered. In no other act was it was covered. So employer used to face difficulty of prolonged mass casual leave. Now 14 days, first of all, 14 days notice has to be given to the employer, even if you go for mass casual leave. So this will enable, the 14 days gap will enable the employer and the employees to settle their disputes. Otherwise, all of a sudden, if somebody goes tomorrow, somebody goes calls for a mass casual leave, and the entire staff goes for a mass casual leave, then things used to be little difficult. Now, since the notice period is there, so that bargaining power of the employees have been reduced a little till that gap period of 14 days, so that both can be on the same level across the table of conciliation. So this aspect is very important, significant, and very appreciable. Then we have the digital process. Now, this again, the digital process records have to be maintained about every aspect, every provision, every register, every facility, every disputes resolved, everything that has been happened, that has been taken place under the provisions of the Industrial Relations Code have to be maintained in electronic form. So no manipulation can happen. Okay, I would not say no manipulation. I would say minimized manipulation is now expected. And this will also help in proper and fair disposal of the disputes. Then we have the Code of Social Security. Now, in this code also, few provisions had come into effect earlier in 2025. Now we have, 2021, I think. So now we have the entire code coming into effect into 2025, and this social security also has amalgamated number of acts, compliance of which was cumbersome, registration was cumbersome, and so it kind of created a confusion in the implementation of the provision, because there were a lot of overlapping of the provisions, of the meanings and the execution. So here the applicability has if you see the chapters, then the various chapters have different applications. They're still different and still easy from the various acts being applicable, because every time there is a dispute or there is any kind of conflict, the specific act would come into play. Here, only a specific chapter has been, if there is any kind of conflict, again, under the specific chapter, under the specific provision, then only that provision would be applicable. We do not have to go in for the other kind of, for the other 9 acts. I think there were 9 acts. So this part is appreciable, and this will reduce the conflict also, no overlapping. So now we have combined registration. We do not have to go, as I said, we do not have to go for multiple registrations, number of registrations. Here, every establishment is required to obtain registration, that is there, but it will be deemed. Suppose if there is a registration under the employees security insurance, then employee state insurance. So in that, if there is any, if there is a registration, it will be deemed to be registered under the Code of Social Security. Then we have the pensions. Now, pensions provision under the Pensions Employees Provident Fund and Miscellaneous Provisions Act have been repealed. However, they still remain in force for the transition period of 1 year, that is 21st of November 2026. So the relevant provisions are still there till 1 year. Then we have the Employees Deposit Linked Insurance Scheme. This also has to continue. This will continue. This has not been repealed. This was enacted in 1976. This has not been repealed yet. Then we have recognized fixed term employment. So all statutory benefits. Now, what used to happen earlier, only the permanent employees, only those employees were given benefits. Now, not only that, not only the fixed term employees, even the casual employees will also get the benefits of social security. So maternity benefits is also there. Maternity benefit will be even for the casual. We did not have maternity benefit for casual employees. That was based on dependent on judicial intervention. Now we have the maternity benefits under the Code of Social Security for casual and fixed term employees also. But then the employer can also now pool in, especially for the provision of creche. If there are only maybe two or three women employees, then creating a creche for them will be cumbersome and it will cost the employees also. The employers can now pool in the creche facilities developed by the government and can use that. So under the Code of Social Security, we have the gig and platform workers also, which were not recognized earlier at all. So as I said, these employees who are working on the audio-visual platforms, on the aggregators, or on the on they who are gig who are freelancers, consultants, they are also under the benefits of Social Security Code. So impact of payments of salaries and social security measures will be seen when any establishment, any factory, any commercial establishment. Now, these are also applicable to commercial establishments. So, if these employ gig workers or platform workers, then the impact on the payment of salaries and social security measures will definitely be seen. Now we have the occupational safety, health, and working conditions. This is one code which has the maximum number of enactment within its ambit, and this also has the maximum number of state enactments also, because there are certain areas, certain sectors which, like for example, the plantation. Now every state doesn't have the plantations, so various states that have plantations, they also have their own respective enactments and respective rules. So this code is going to be beneficial only when all the states also bring about their respective respective rules and respective enactments in line with the Code of Occupational Safety and Health and Working Conditions. Till then, we will be seeing the employer will be burdened with registration, compliance, and other benefits that are to be provided, mandatory, that are to be provided under the occupational safety and health and working conditions in the as provided in the earlier regime, not just this code, as provided in the earlier regime. So this will be a little cumbersome till the enactment and repealing takes place. Now, local shops and establishment legislations to remain in force. As I said, not just the enactments, the local shops and establishment rules and regulations, the legislations under the Shops and Establishment Acts and respective state acts under the Shops and Establishment Acts, they will continue to remain in force. Then we have the registration and license. This is one beneficial thing. We will have a single registration and common license for different activities. Earlier, they used to have different licenses and different registration for various kind of activities. Now, they will have a common license for different activities. Then failure to registration might lead to disbarring from hiring employees. So it is not just mandatory. If it is not obtained, if the license and registration is not obtained as per the code, then it might also lead to disbarring of hiring employee, meaning closing and shutting down of the units, of the establishments. Then employment of women during night shifts. During night shifts, it was not very common to see women employees, and a few sectors, the hazardous sectors, were actually prohibited from employing women as workforce. But now hazardous sectors have also been opened up, which is beneficial to the employers to a certain extent, that they will at least have a workforce where women can be also employed along with the male workforce. Otherwise they were restricted to provide only for the male workforce, employ only the male workforce. And if number of eligible or number of competent workforce was not available, then it led to shortage of workforce. Now here, if eligible and competent women workforce is available, they can again go for women for employing women workforce also, but then they will have to provide for the basic facilities and amenities for safeguarding the women employment, and they will have to seek consent. Consent is mandatory, and this consent will have to be a written consent. It is not an employed consent. So this will be a written consent. This will also safeguard the employers from getting into trouble later. And nobody can accuse the employers that they were forced to work under difficult conditions, or in hazardous sectors, because hazardous sectors are now legally open for women workforce. Then in this code, employers as well as employees are both accountable, meaning to maintain the risk and healthy work environment, it is the duty of the employees also. And if an employee is found to be, there's a provision where if the employee is found to be negligent towards his safeguarding, towards his safety, then the employee can also be charged with liability, and the employer in that case will not be charged with liability. So this is a very welcome step. Otherwise, any time if there happened an accident, then it was the sole liability of the employer, and it was very difficult to prove that the employer was not negligent. It was the negligence of the employee. Now, then we have the welfare facilities to be provided at commercial establishments also. Welfare facilities were provided in factories, in establishments which were manufacturing units, in other in the corporates, everywhere. But now commercial establishments also, like any office, will also have to be compliant with the provisions of this code. So this is also a very major development, very major amendment in the under this code, because commercial establishments were never covered under the labor laws. Then we have the phased implementation timeline also, because it is still in continuity, because it is still a large part of compliance has to take place under the registration and licensing schemes. Now this provision of a gap or a breather or a breathing space has been provided. So for large enterprises where the employees are more than 500, it is immediate, because they already had the most of the labor law provisions applicable. So it is, for them it is immediate. For medium, that is employees 100 to 500, additional transition phase is for post phase 1, that is now for 1 more year they will have a breathing space, so they can comply, because in this medium and in this medium enterprises category, most of the MSMEs will be included. Now for MSMEs, many of the provisions were not applicable, so now for them they will have a breather, they will have a breathing space. For small enterprises which had only 20, 30 or 40, 50, most of the acts were not even applicable. For example, the Provident Fund, it was not even applicable to them. So now they will have 2 years for full adoption, because now every aspect, even Provident Fund, has to be provided for small enterprises. So all the enterprises, whether small, whether medium, less than 100, more than 500, every enterprise has now been brought within the ambit of the code. So for their benefit, there is a breathing space. They have been given time for compliance and time for full adoption of the provisions. So now we come to the last stages. Last slide is that there are major challenges. What are the major challenges? Like definition of workers and employees. There are still certain conflicts of uh, meaning and definition. For example, for workers under the Code of Wages, the threshold is different, and that is only 15,000 employees, and 15,000 income, the employee earning 15,000 rupees per month. Now for industrial disputes, industrial relations, the meaning and definition of workers includes 18,000 per month, an employee earning 18,000 per month. So there are certain conflicts, minor conflicts between the definitions that have to be taken care of. Then the salaries threshold still exists in defining workers and employees. So if there are workers, there are employees that are defined in two different ways in two different codes, then the salary and the other emoluments and the other parts will be decided accordingly. Of course, the definition of wages has now been limited to only the basic and the DA. And if there is any other remuneration, now remuneration part was also variedly defined in very different, all different kinds. There are 12 different definitions of wages. But now any wage will cover only the basic pay and the DA. Rest of the remuneration will be excluded. But if they are more than 50%, then the excess part of that 50% will be again included as wages and as part of the wages in the definition of the wages. Then, as I said, uncertainties caused by concurrent legislation as OSH code does not subsume local shocks. As I said, the last one, it does not does not repeal all the state legislations. So even if this act comes with the rules, yeah, this code comes with the rules, until and unless the code specifically mentions that there is a specific notification for the state legislations, this part will still remain a gray area and will still continue to contribute to the conflicts and pendency of the cases. So employers will have to take care of this part, especially when they are framing their policies, when they are framing their contracts. Now, contracts are mandatory, so all these parts will have to be mentioned in the contracts, and contracts have to be digitally maintained. Employment contracts have to be digitally maintained. So whatever is contained in the contract will form evidences against the employers also. So this part has to be taken care of by the employers specifically. So I think, yeah, that is the end of the session. So if you have any queries.
Thank you so much, ma'am, for sharing your valuable insights with us. You can now stop sharing your screen and we can move forward with the questions. Okay, everyone. So we are now open to the questions. You can post your questions in the live chat. Okay, so we have our first question, ma'am. What are the
Yes,
biggest compliance challenges HR is facing under the new wage code?
okay, for HR is the same thing. Yes, please.
No, ma'am, you can
Just a
continue.
minute. Yes. So HR for HR again is the same thing, just like the employers, because HRs will be framing the policies.
Yes.
And as I said, there are conflicting provisions with respect to the state legislations and the central codes. So the HR who is employed in a particular state will have to take care of the state legislations there, and accordingly, in line with the central code, of course, leaning towards the state until unless the provision is specifically repealed. But then the state legislations will have to be taken care of in framing the employment provisions employment contract, because contracts are also framed by the HRs. So all those policies, all those provisions will have to be borne in mind while framing the clauses of the employment.
Okay, ma'am. Okay, so our next question is, does the new labor code actually mandate a 4-day working week, or is it optional for employers?
No, mandate is 8 hours per week. 8 hours per day. That is mandatory. After that, for overtime and all those monetary liabilities will incur on the employer. So that can be as per the agreement between the employee and the employers. That is optional. So apart from the mandatory 8 hours period, if an employer, depending upon the conditions, his work conditions, his work requirements, and other conditions like geographical conditions and everything, if on the basis of that, if he needs certain, or the sector that is working, if a certain sector needs a more number of hours, then that can be done on the basis of agreement. That has to be mandatory. Agreement is mandatory.
Okay. Okay, so next question is, what immediate HR process changes are critical before full implementation of the codes?
No, without full implementation, there cannot be significant changes, because policies have to be in line with the laws. Okay, so but then yes, since the laws are there, notification has been printed in the Gazette. Rules are still being framed. So what the rules will do is only to provide the procedure as per the provisions. So that will be more for the authorities, the concerned authorities. Rules are basically how a certain thing has to be done. So that will be more for the concerned authorities. But then the policies can still be in line with the provisions of the code starting from today.
Okay. So next question is, what PF and gratuity changes are introduced in the labor laws?
Okay, for that, we will have to do a complete session on that. But otherwise, uh, now every employee has been benefited with gratuity. Even the casual work, I mean, the permanent, the fixed term workers, and also the continuous period of service has been maintained as it was in the earlier regime, that is 5 years of continuous service. And it is not optional that a person cannot have a gratuity for his employees if he has less than 100 people, or less than 20 people. Now every establishment has to have a gratuity facility and pension facility, provident fund facility.
Okay. Uh, Next question is, how is the date for filing annual returns determined?
Yes. So, a date for filing annual returns. Now, annual returns is mandatory in these codes, but every state also has a mandate as a yearly time. There are half yearly and annual returns. So every state has a fixed time. So if any state has a particular fixed time which is different from the central notification, then that particular enterprise in that particular state has to file the returns as per uh, the state notification. So that will have to be taken care of depending on the states. Every state will have a different annual return
Okay.
date.
Okay.
Yes.
What changes should employees expect in appointment letters and HR policies?
Yes. So HR policies, see, so first of all, the HRA allowance has now been included as part of wages if it is more than 50%, going more than 50%, right?
Yes.
If there are any perks, any remuneration that have been given in kind, so the value of that kind, if it goes beyond 50%, then that will also be incorporated in wages. So it has to be specifically mentioned in the employment contract, that what part is, because that breakup will, what the companies will do is they will keep the flexible part intact. to come within the CTC.
Yes.
So the breakup, it will be better if the breakup is provided accordingly. What part is going under remuneration, I mean the flexible remuneration, what part is going under the basic pay and the dearness allowance. All the breakup must be specifically mentioned to avoid any litigation, because there are certain litigations which can be even brought about without going into the industrial dispute, that is the damages. Okay, so for damages, then you can always claim higher. So employment contract should provide the basic salary, the remuneration, the facilities, the social security facilities. Everything should be provided clearly. That is that is beneficial to the employer more than the employee.
Yes, ma'am. Okay.
And one more thing, that is
Yes, ma'am.
one more thing I would just like to add.
Yeah.
Now, since sexual harassment has become a major concern as far as bonus and gratuity are concerned,
Yes.
so the HR should frame earlier. I mean, I'm doing posh also. Not many organizations, even big organizations, are not having a posh policy.
Yes, ma'am.
Okay.
Yes.
Now in sexual harassment, in this code it is not mentioned what sexual harassment. Posh is specially for females, for women, but
Okay.
in this code it is only sexual harassment which
Okay.
is mentioned. So
Yes.
it can be for both, for men and women both. So
Okay.
in your employment policy, you should also have, the HRs should also have uh, now, I mean, they do have posh mentioned, posh incorporated, posh policy incorporated, but now they should have also for the men,
Okay.
because sexual harassment can happen between men and men, men and women, women and women.
Yes,
So
ma'am.
accordingly, now improvised posh policy or sexual harassment policy should be incorporated in the employment contract,
Person.
and the
Yes.
penalties and the procedure, yes, procedure also, how it should be redressed, because posh inquiry committee is only for the women
Women. Yes.
victims. So the sexual harassment policy in HR policy can also provide for mechanism of redressal of disputes or complaints under the sexual harassment, so that gratuity and bonus are taken care of properly.
Okay, ma'am. Okay, so next question is how to ensure compliance where rules are not yet framed.
Yes. So as I said, when the rules are not yet framed, that means the specific code is not fully in implementation, because every code comes in in implementation only when the rules are also framed, because the rules provide for the procedure how to implement the specific provisions. So till those rules are not framed under the specific codes, the earlier rules that were applicable in the earlier regime, the earlier 29 acts had their rules also. So those rules that were applicable to a particular act which are incorporated in these any of these codes will have to be followed even today, till we come with the government comes with the new rules and repeals the earlier rules.
Okay, ma'am. Okay, so
Yes.
our last question is what is the impact of inconsistency between prevailing laws, rules under state legislation and the new labor codes?
Yes, so the impact will be still litigation will be a major concern for the employers. So it is better to start complying with the provisions of the act of the code, and having reworking on the policies to bring an alignment in the provisions, in the clauses of employment and working conditions in their establishments, in their enterprises, which are in consonance with the present codes and the present existing the rules that are still in force. So that I'm pretty sure if the rules are made under these codes, then the previous rules will also be taken into consideration, so that there is no major divergence for compliance.
Yes, ma'am.
Yes.
Okay, so thank you everyone for joining today's session and
Thank
for your active participation. As we conclude, I would like to sincerely thank our speaker for sharing such insightful knowledge and all the participants for their active presence and valuable time. Ma'am, would you like to say something?
It was my pleasure for being invited. on labor law, because labor law is a major concern for enterprises, whether now since commercial establishments are also included.
Yes.
So it was a major concern. So it was a pleasure sharing my views and sharing my experiences as a lawyer also.
Yes,
I'm
ma'am.
grateful for that. Thank you so
Thank you,
much.
ma'am. Thank you for associating. On behalf of Education Nest, we truly appreciate your participation and hope today's webinar has enhanced your understanding. Thank you and have a wonderful day ahead. You know what you have to do, right? Do like, share, comment at this webinar. You can even put suggestions for our next webinar. All our social media handles are mentioned below. Okay, till then, take care. Bye bye. Thank you, ma'am. Bye bye.
Thank you. Thank you. Thank you.